8, 7.
Welcome, everyone. Welcome to the Unusual Crammer 2020. For those who have been with us in the past, welcome back. And for those new to the Crammer, we hope you enjoy the experience. It is the world's best legal event. In the Crammer this coming week, we summarize a year's worth of legal content, case law highlights in bite-sized sessions with takeaways for you. That's the usual bit. But 2020, of course, has been, well, rather unusual. The Unusual Crammer explores some of the major themes and trends of the year, including an unusually agile and flexible workplace, unusual risks and opportunities for business and industry, unusual innovation and legal decision-making, and sadly, some unusual business rescue and restructure. It will be presented to you in an engaging format by facilitators each day this week with some presentations in unusual places. In recognition that business has been extremely hard for many, we will also be showcasing businesses on our platform each day with unique, challenging, or unusual stories to tell. In this way, we hope that they and you can use the Crammer platform to promote and support each other and collaborate, network, and learn from a variety of different experiences and hardship. We hope you take advantage of that. This year's Crammer is brought to you by 5 facilitators, including myself, who will be navigating a variety of legal topics. I will be on screen tomorrow, navigating the unusual workplace, where we publish a workplace survey that had almost 200 people respond. This will be discussed with experts in the IP and employment law sectors, an expert on human capital, and of course the owner of Savile Row Architects and Design, who designed and distributed the survey across our networks. It's an amazing conversation, and I encourage you all to be there tomorrow. On Wednesday, Peter Fasaki will be navigating his place on the Crammer platform, and I would like to hand over to him to introduce his session. Please enjoy our Crammer.
Thank you, Darren. My name is Thando Manenza, and I'll be your MC and facilitator on Wednesday. We will be discussing some of the unusual circumstances that have occurred in this year and how these circumstances have affected legal obligations in the construction industry and lease agreements and insurance claims. Our first speaker, Mr. Vian Menkes, will be discussing how traditional force majeure clauses have not quite adequately dealt with some of the pitfalls and issues that have been faced in the construction industry this year. Our second speaker, Ms. Gabrielle Dare, will be discussing how COVID-19 has affected lease agreements and how it's affected it both now and into the future. And lastly, we'll conclude our discussion with Ms. Subisile Kusi, who will be discussing some of the issues that have happened and occurred and that our courts are presently dealing with in relation to insurance claims. I am looking forward to seeing you all on Wednesday, and I hope you enjoy the rest of the week. Thank you, Darren.
Thando, firstly, I must apologize. You don't look a little bit, even a little bit like Peter. You don't sound like him either. But thank you very much for that introduction. And now, finally, over to you, Peter.
Hi, everyone. Thanks, Darren. I'm Thando Manenza, and I'll be presenting. No, I'm just kidding. I'm Peter Fasaki, and I'll be your facilitator on Thursday. Darren, thanks for the introduction. Now, as we know, it's an old saying that necessity and therefore opportunity is the mother of invention. And while times of crisis are certainly most challenging on a humanitarian level, there are few times as fertile for opportunities to develop, whether it be in a local or in a global context. We'll look at some historical examples on Thursday that I'll introduce. But for now, let me say that this is the context of our discussion, which is themed Unusual Opportunities. In our talks on Thursday, we're going to take a look at opportunities brought about by the pandemic from essentially 3 perspectives. The first is direct needs of the population with reference to the development of vaccines and therapies to combat the pandemic. The second is the advancement of the need for existing technologies that the pandemic has created. And the third is business survival in the face of circumstances that many would see as certain closure. In respect of business survival, we have Portia Manzini, one of our associates, who will be discussing the advantages of timeous utilization of business rescue proceedings with advocate Johan Smit, who is a specialist in this field. In respect of COVID-19 vaccines and therapies, Dr. Charlene Ripnarayan, who is one of our senior associates, will be having a very interesting and a technically detailed discussion on COVID-19 testing and treatments with Dr. Yvonne Holt, who is the Chief Medical Officer at Next Biosciences. And finally, in respect of the need for existing technologies, Tapelo Montong, one of our senior associates, will be informing us of the rapid development of 3D printing technologies over the past decade or so, and they'll also be emphasizing their utility in times of crisis. They'll then also be educating us on some intellectual property considerations relevant to 3D printing. Our program on Thursday is one that we're particularly excited about. It's packed with experts and topical discussions, and we look forward to learning from the speakers and their contributors, and also to engaging with you, the attendees, on Thursday. Enjoy the day and enjoy the week, and we hope you learn as much from this as we have learned in preparing it. Thanks, Darren. Back to you.
Peter, thank you very much. That does sound super interesting, and I'm myself looking forward to that session. I turn now to Nick Rossley. He's the man in the bow tie to tell us what's in store on Friday.
Hi, everyone. We're, of course, exceptionally excited about the Friday day, and I thought I'd show you through my bow tie that it will be the fun day of the Crammer. Lots of really exciting topics that will be discussed. So the headline topic for the day is unusually private. And we look at how the law has its impact in your private life. So we start off with a conversation between me and Demi Pretorius, which is titled On Liability, a very clever play on words, as we're talking about specifically your liability for your conduct online. And we'll look at fake news, WhatsApp and contracting over WhatsApp and direct messages. Yeah, and it's a really, really great chat that Demi and I had. Nicole Smallberger will talk about copyright in relation to tattoos and your body art, and she'll also talk about copyright in relation to your virtual self, so avatars, which is a really fascinating topic and very topical considering the case law developments in the United States on body art. But I'm not going to spoil that for you now. Danielle Roberts will then talk about POPI or POPIA, the Protection of Personal Information Act, and give you useful takeaways on how the landscape is changing in relation to how your personal information is governed online. So who should watch on Friday? I'd say with fake news topic, perhaps anyone whose mom sends videos over WhatsApp that are possibly fake news. So that's most of us, yeah. And I guess also the fact that it's about personal information. There's two sides to the coin to that, is because firstly it should be interesting and relevant to each of you in your personal capacity, but also on the flip side of that coin, there's a commercial element to everything, and your businesses would be very well placed to look into whether whether you need to have special safeguards in mind in relation to personal information, copyright, and just general online liability. Thanks. Back to you, Darren.
Thank you very much, Nick. Well, if Friday is going to be fun, today certainly looks colourful. Jenny Pinar, what's in store for us today?
Morning, Darren. Thank you very much. Thanks, everyone. It's so weird to look out at the screen and just see my fellow colleagues and not at a room full of familiar faces that normally join us every year for the Crammer. But warm welcome on a cold Monday morning. We have a really jam-packed morning for you. Our theme for today is the unusual times. And I think all of us have experienced life in a completely different environment in the last 6 months. So what we're going to focus on today is we've divided our morning up into 4 different sessions. The first session will be an unusual panel discussion between Mia de Jager, Cohen Grootboom, and Alyssa Nayana. Each one of them have chosen to speak to you about something which is unusual, but something that has been in the media relating to COVID-19 regulations, their constitutionality, questions of are we paying too much for our toilet paper and face masks, and how can a business like Booking.com get rights in a trademark. So that's the first panel discussion. All 3 of those discussions will run back to back, and there'll be time for questions and answers afterwards. After that, we're going to switch over to a slightly more IP-directed environment where Karima Sheikh is going to talk to us about copyright, but specifically relating to giving you great advice on it, like a cheat sheet that you need to have to ensure that when you give somebody a mandate to create something for you, that you still retain your rights. Sophia Smallbones is then going to talk us through a rather unique situation that we have in South Africa in relation to acquiring patent rights in relation to partially valid patents. And there'll be time for questions and answers after each of their sessions. We then have a rather special guest after that, Advocate Stephen Budlander, who's a senior counsel at the Johannesburg Bar, and he's going to tell us what it's been like to be counsel in these unusual times and to try and run a case from the comfort of your office environment, either at home or in your chambers. I think it's probably very likely that with many of us, there were many times where they had to advise the judges that they were on mute and that nobody could hear them. So I think you'll find that very entertaining and insightful. We're going to wrap up the morning with 2 unusual stories, and I'd really like to encourage you to stay to listen to those. We have found tremendous support from clients who've really struggled through difficult times in the last 6 months, and they've reminded us that we really are privileged to be able to say that we could carry on working and that the impact was not as major as it was in small business. So that's today's lineup. Grab a cup of coffee, pull your screen closer, and I think we can start off with our first panel discussion. So over to you, Mia.
My name is Mia de Jager, and during these unusual times, I will be guiding you through the pitfalls of demand shocks, price gouging, and the notion of temporary dominance. Although these concepts were around pre-COVID, they have now become part of our general vocabulary, much like flattening the curve or you are on mute. We have all been caught in the rain without an umbrella. When a salesman walks past you, you might not mind paying that little bit extra to have that umbrella. The world was caught in the rain by not having sufficient face masks when the COVID-19 outbreak occurred. Those with stock could profit. Naturally, demand increased, prices went up, and the competition authorities stepped in. Today, businesses need to be aware that in the midst of a pandemic, that a seemingly commercial response to supply disruptions could lead to prosecution by the competition authorities. Price gouging is a sharp increase in the price of essential items precipitated by supply shortages or demand shocks, as we have seen with face masks, sanitizer, and even toilet paper. In an attempt to prevent price gouging, the Minister of Trade, Industry and Competition, Ibrahim Patel, promulgated regulations which prohibits dominant firms from selling essential goods and services at excessive prices. Naturally, during a pandemic, the demand for certain products will increase. The rules, which were aimed at protecting consumers, unfortunately had a few unintended consequences. While companies generally have the freedom to sell their products at a price that the market dictates, this is not the case during a state of national disaster. Dischem and a small family-owned business by the name of Babalegi have recently been prosecuted and fined for selling essential goods at what the Competition Tribunal determined to be an excessive price. However, the tribunal came to this conclusion without applying its standard economic test to establish dominance. It is internationally recognized that the South African Competition Authority's response to the demand shocks caused by the pandemic has been robust. They prioritized excessive cases with a view to curb anti-competitive behavior and to protect consumer welfare. Although the response is aligned with the Commission's mandate to promote and maintain competition, there is a concern that the approach actually disincentivized competition to the detriment of consumers. In March, the Commission invited consumer complaints of excessive pricing in response to panic buying of essential goods. Many companies settled by paying a fine with or without the admission of liability. It is important to understand that the prohibition against excessive pricing is reserved for dominant companies. That means companies that have around a 35% market share or those with market power may not charge excessive prices. Market power means that a company can control prices, exclude competition, or behave independently of its competitors, customers, or suppliers. Babalegi, who would not ordinarily be regarded as a dominant firm, was found to have market power because it was able to increase the margins on 76 boxes of dust masks. Furthermore, Babalegi and Dischem were charged with excessive pricing for sales it made before the excessive price regulations were introduced. The tribunal's finding that Babalegi and Dischem contravened excessive pricing regulations came as a surprise to many in the legal profession. Both companies took the tribunal's decision on appeal to the Competition Appeal Court. However, Dischem withdrew its appeal and will now pay the 1.2 million rand fine imposed on it. Babalegi's appeal was heard on the 4th of September and judgment should shortly be delivered. The Babalegi and Dischem cases are full of unusual features. The first is that the entire hearing and the examination of the economist was all done over Microsoft Teams. The proceedings were seamless and potentially will lead to more matters being heard over the likes of Teams, Zoom, or Hangouts. Secondly, the investigation was done within an extremely short time frame. For example, in Babalegi, the Commission brought its case referral on the evening of Good Friday, with Babalegi's response being due just after Easter weekend. At the Competition Appeal Court hearing, Judge Davis even asked, why on earth did it have to be rushed like this? Thirdly, dominance could previously only be established within a particular market, which consists of a product and a geographic component. For example, the manufacturing and supply of dust masks in Gauteng. However, in this matter, the Commission skipped over this step. The tribunal ultimately found that the companies had temporary dominance or market power without defining the market in which they held such a dominant position. Why this is unusual is that the special responsibility reserved for dominant companies not to engage in exploitative practices only applies within the market in which they are dominant. It is therefore important that this market must be properly defined. The Commission's approach has been widely questioned in this regard. It is also worth noting that the penalties against Dischem and Babalegi have been structured as contributions to the Solidarity Fund, which may not truly fall within the definition of an administrative penalty under the Competition Act. The case before the tribunal has set a precedent that companies can be regarded as dominant simply because they are able to increase their margins. The regulations, which were designed to stop large and dominant firms from excessive pricing, is now being used against small firms. in the legal papers of the Health Justice Initiative, Open Secrets, and the South African Human Rights Commission, who intervened as friends in the court in the Babalegi and Dischem matter, they listed examples of cases which the Commission has prosecuted. For example, a company which made a profit of 500 Rand was fined for selling masks for 15 Rand after paying 10 Rand for them. This surely cannot be the intention of the regulations, and we hope that going forward that they will be used for the purpose that they were promulgated. So what does this judgment mean for your company? Firstly, you must be mindful that the competition authorities now recognize temporary dominance even for small firms. The strict rules reserved for dominant players may now apply to small companies. This means that the abuse of dominance provisions is potentially catching a broader category of parties. And while the disaster regulations are in place, anyone with excessive margins may be considered dominant. Secondly, be mindful that price increases and excessive margins may be scrutinized by the competition authorities if triggered by a complaint. Now might be the opportune time to do a health check of your company's pricing movements during this state of disaster. Lastly, if you are the subject of an excessive pricing investigation, it might be tempting to settle the matter. However, the Commission has been criticized for going after what is described as low-hanging fruit, and we encourage you to obtain legal input before admitting liability or paying an administrative penalty. During these unusual times, companies must be unusually cautious not to fall foul of the Competition Act. It is no longer safe to say that the market will dictate the price. We hope that the Competition Appeal Court will shortly shed some light to assist companies in navigating these unusual times. I now turn to my colleague and fellow Crammer, Alyssa, who is in Cape Town. Thank you.
Hi Crammers, I'm Alyssa Nyana from the Cape Town office, and I'm coming to you from the beautiful wine cellar here at Fairview in Cape Town. Well, because it's 2020, and why not? It has been a roller coaster of a year, filled with surprising twists and turns and unusual stories. The legal industry has been no different, and the Booking.com case was unusual in many respects. Firstly, the decision was handed down by the US Supreme Court of Appeal, which is the equivalent of the South African Constitutional Court. Now, it's not often that IP matters go all the way up to the highest court in the land, and it was unusual that what was essentially a trademark decision was handed down by the US Supreme Court of Appeal. Secondly, and what actually attracted me to this case, was that the majority decision or opinion was written by the now late Justice Ruth Bader Ginsburg. Justice Ginsburg was an American legal icon with an impressive career. In addition to her insane academic accolades and court wins, she was appointed as a US Supreme Court judge in 1993, where she served until she passed away a few weeks ago. Justice Ginsburg was a strong advocate for gender equality, and she wanted to be remembered as a person who used whatever talent she had to do her job to the best of her ability. So, needless to say, I am a huge fan, but now let me actually tell you about the Booking.com case. Booking.com, the well-known online travel company, applied to register trademarks incorporating the term Booking.com. The United States Patents and Trademark Office, or the USPTO, refused to register the trademarks on the basis that the term Booking.com was generic. Now, Booking.com was under no illusion about their trademarks or the descriptive nature of their trademarks. They offered booking services. The trademark had the word booking in it, and .com merely informed consumers where they could be found online. So Booking.com went in equipped with an arsenal of market survey evidence as well as evidence of use to show that although the trademark was descriptive, it had acquired a secondary meaning in that consumers associated the marks exclusively with them. Now, unfortunately, the USPTO was having none of it. They held steadfast in their view that the term booking.com was generic and that no amount of evidence of use would render it capable of registration. So the legal issue that then wound its way up to the US Supreme Court of Appeal was whether the term booking.com was generic or whether it was merely descriptive. If it was held to be generic, then no amount of use or survey evidence would render it capable of registration. On the other hand, if it was merely descriptive, then booking.com was entitled to rely on their survey evidence and evidence of use to show that the term had acquired a secondary meaning. Now, in considering this legal issue, Justice Ginsburg considered three fundamental factors. Firstly, a generic term names a class of goods or services, as opposed to describing a feature or characteristic of those goods and services. Wine is the name of a class of goods. It is therefore generic and incapable of registration as a trademark in relation to wine. Zesty wine, on the other hand, describes a characteristic of the goods and is capable of registration as a trademark, provided you could show that it has acquired a secondary meaning. Secondly, when considering a composite mark like booking.com that incorporates the word booking and .com, it was crucial to consider the mark as a whole. Now, this is Trademarks 101. You always consider a trademark as a whole and never dissect it into isolated portions. Thirdly, what does the term booking.com mean to consumers? So Justice Ginsburg said, if consumers truly perceived booking.com as a generic term, then you would expect them to say things like, well, who offers the best booking.com? Or you would expect them to refer to all similar service providers as a booking.com. However, you don't hear consumers referring to TripAdvisor or TravelGround as a booking.com. So Justice Ginsburg held that the term booking.com did not name a class of services and therefore was not generic. Justice Ginsburg rejected the USPTO's suggestion of a blanket rule that all generic .com marks were incapable of registration because they were generic. She, however, was not prepared to hold that all generic .com marks were automatically capable of registration as a trademark. Ultimately, whether a generic .com term is considered registrable would depend on how consumers perceive the mark. So, what does this mean for you? Firstly, it means that generic .com trademarks or terms are registrable as trademarks. Doing so requires you to adduce evidence to show that consumers do not perceive the term as naming your goods or services. Such evidence would include market survey evidence, dictionary definitions, examples of how consumers or competitors are using the mark in trade, as well as evidence to show that there is some other generic term by which the goods or services could be named. Secondly, you would have to show that your mark has acquired a secondary meaning in that consumers associate it exclusively with you. Again, such evidence would include market survey evidence and evidence of use. If you are successful in securing a generic .com mark as a trademark, it is important to bear in mind that your rights would be limited in that you would not be able to restrain third parties from using the descriptive elements in the mark. So much remains to be seen on how far booking.com would be able to extend their monopoly, would they, for example, be able to restrain third parties from using the term booking.net or bookingsnow.com? So whilst it seems like a very costly exercise for limited rights, Booking.com was willing to incur those costs to prevent competitors from using the identical trademark, for example, on storefronts, and from diluting their trademark by selling branded goods bearing the well-known Booking.com trademark. So if you have competitors that are using a term that is identical or very similar to your generic .com mark, or any generic domain name for that matter, it is certainly worthwhile considering registering that term as a trademark. So that is the Booking.com case in a nutshell. That's it from me in Cape Town. I now hand you back to the Gautengers while I go investigate whether this wine over here is actually zesty.
Regulations. The COVID-19 regulations are irrational. This was the findings of Judge Davis just a couple of weeks ago on the 2nd of June, hearing the matter of De Beer versus the Minister of Cooperative Governance. This is Leroy Gouging, and this is Military Cuts, his barbershop. For the uninitiated, on 15 March 2020, what to many now seems like a lifetime ago, the South African government declared a national state of disaster in accordance with the Disaster Management Act 57 of 2002, pursuant to which the government instituted a hard lockdown as part of the measures to curb the spread of the coronavirus. The declaration of a national state of disaster allowed the minister to issue regulations regarding a wide range of aspects, including, amongst many others, the institution of a mandatory curfew, banning of the sale of alcohol and cigarettes, the imposing of restrictions on outdoor exercise, prohibition on gatherings, attendance of funerals, the sale and the purchase of so-called summer clothes, and even restrictions on the trading of hairdressers and barbershops. Why am I in a barbershop discussing lockdown regulations? Well, you see, you process these statistics just a little bit different when it's no longer just numbers, but names, businesses you frequent, people you know. In a nutshell, government's reasoning was, and to an extent still is, that the ends justify the means. At first, the general population accepted this and the resulting limitation on their rights. But the novelty soon wore off, and the reality of the limitations soon came to bear, which led to various court challenges, including the De Beer case in question. The court considered the validity of the regulations with reference to the so-called Rationality Test, which has been considered by our courts in a wide range of cases throughout the years. The Rationality Test, as explained by the court, entails that in every instance where the power to make a specific regulation is exercised, the resulting exercise of that right, that is to say that the regulations themselves must be rationally related to the purpose for which it was conferred. In respect of this approach adopted by government, I'm reminded by the theory in moral philosophy known as consequentialism, which essentially entails that if a good is morally important enough, any means of achieving it is acceptable. This, in turn, reminds me of the well-known debate in the field of ethics regarding consequentialism and intentionalism. For example, if you save a drowning man while trying to steal his watch, is that a moral act? I'll leave that to you to decide. Back to the De Beer case. Essentially, the court found that there was a disconnect between the means and the purpose for which the regulations were implemented. I would like to read just two short excerpts from the judgment towards this point. The court writes, to illustrate this irrationality further, in the case of hairdressers and barbershops, a single mother and sole provider for her family may have been prepared to comply with all of the preventative measures proposed in relation to a specific alert level regulation, but must now watch her children go hungry while witnessing mini-cab taxis pass with passengers in closer proximity to each other than they would have been in her salon. She is stripped of her rights of dignity, equality, to earn a living, and to provide for the best interest of her children. And the clear inference I draw from the evidence is that once the minister had declared a national state of disaster, and once the goal was to flatten the curve by way of retarding or limiting the spread of the virus, all very commendable and necessary objectives, little or in fact no regard was given to the extent of the impact of individual regulations on the constitutional rights of people and whether the extent of the limitation of their rights was justifiable or not. The starting point was not, how can we as government limit constitutional rights in the least possible fashion while still protecting the inhabitants of South Africa, but rather, we will seek to achieve our goal by whatever means, irrespective of the cost, and we will determine, albeit incrementally, which constitutional rights you, as the people of South Africa, may exercise. The court ultimately found that the regulations were invalid and unconstitutional. However, it provided for a period within which the minister may amend the regulations, as the court calls it, with due consideration for the limitation that each regulation has on the rights guaranteed in the Bill of Rights as contained in the Constitution, which the minister subsequently did, for the most part at least. The judgment is flawed, but then again, so is the government's regulations. The judgment has been criticized for, doing somewhat of a wholesale declaration of invalidity and unconstitutionality, whereas it is argued that the court should have considered each one of the regulations with reference to the tests which it has prescribed. That being said, the legal principles remain sound. The South African government is by no means singular in imposing such restrictive regulations. And this has been a trend all around the world for governments to curb the spread of the virus. This is merely the regime flexing his muscle. Why? Well, because it can. Now, you may say to yourself, does this really matter? I mean, the lockdown regulations have now been relaxed. It's all water under the bridge. Well, not really. I think it's really still relevant, specifically in the context of this discussion, and that is to say, the wide powers that government has. It happened long before COVID and will happen long after. The government, in exercising this extensive power, often with good intentions, tries to enact or issue regulations to facilitate the ease of doing business while protecting rights, and end up doing the exact opposite, which is to infringe on rights and hamper the ease of doing business. So what does all of this mean for you as a business? What can, or in fact, should you do? I think the point is that you need to be an active corporate citizen and engage with government, particularly in relation to your industry. As soon as the process for new laws in your industry is enacted, you should participate. Consult an attorney or legal representative in relation to making the necessary submissions to government on the publication of new legislation. Participate in grassroots and other civil society organizations in your industry. Make your voice heard. Have a say. I would like to read one more relevant paragraph from the judgment in respect of where the court quotes the Day of Affirmation address by the U.S. Attorney General Robert F. Kennedy on June 6, 1996 at the University of Cape Town. The essential humanity of man can be protected and preserved only where the government must answer, not to just the wealthy, not just to those of a particular religion, not just to those of a particular race, but to all of the people. And even a government by consent of the governed, as in our constitution, must be limited in its power to act against its people, so that there may be no interference with the right to worship, but also no interference with the security of the home, no arbitrary imposition of pains or penalties on the ordinary citizen by officials high or low, no restrictions on the freedom of men to seek education or to seek work opportunity of any kind, so that each man may become all that he is capable of becoming. I'll end on this concluding remark. While the intentions may have been laudable, it is important for government not to lose sight of the method in pursuit of the outcome. Thank you.
that there's been a lot of interest that's been piqued by your presentation. So we've got a couple of questions that have come through our chat line, which I think would be great if you could answer them. Mia, perhaps we can start with you first. There's been a question as to why do you think Dischem withdrew their appeal? Can you perhaps shed some light on that for us?
Yes, Jenny. So Dischem publicly stated that they withdrew the appeal for public relation considerations and not because it was not sound in law. Unfortunately, they were being compared to the PPE scandal, and unfairly so, I must add, and they therefore withdrew just to prevent any potential reputational fallout.
I understand. I think there are a lot of companies, often the decision to take a matter further is based on, reputational issues and matters outside of the actual straight law issues. Alyssa, speaking about enforcement of rights, what do you think is the best way to challenge trademark infringement? There's been a question from one of our guests, and we'd like you to shed some light on that for us, please.
Thanks, Jenny. Well, the best way, and actually the only way to challenge trademark infringement, is by registering your trademark. So that's the only way you can actually institute proceedings on the basis of trademark infringement, is if you've got a registration. If you don't have a registration, you will be forced to rely on your common law rights or your reputation that you've built in the trademark. The difficulty with this is that the first step in such proceedings is to actually show that you have a reputation in that mark, which can be costly because you've got to adduce quite a bit of evidence to prove that you've got rights in that mark. So registering your trademark is always the easiest and best way to enforce it.
I think it's not out of place to say that as trademark attorneys, we spend a lot of time convincing our clients that they must get their trademarks registered, because it really is the best way to try and enforce those rights. Cohen, what do you think? There's been a question from one of our guests. What do you think small businesses need to do to get government to listen to them when they make new regulations? I think you've highlighted today that the very sort of strict rules that were put in place with COVID-19 meant a lot of businesses really struggled simply to survive. So what advice have you got for small businesses on that front?
Thank you, Jenny. I think it's a very practical question in the sense that the public participation, I think, is fundamental to our democracy and a constitutional state such as ours. And without that, a law is essentially invalid. How you as a small business can participate or make your voice heard, I think practically is, first of all, to be involved in your industry. Don't just sit back when laws are made and kind of just go with the flow, but to actively participate in, the imbizos, the public hearings, the ward committees and community workshops, African peer review mechanisms, and other, for example, open government partnerships forums that would lead up to a law being enacted. Put comments, make suggestions, and usually government will take that, or should take that into consideration when making new laws. Even as a small business, I think don't underestimate your value and the contribution that you can make.
Yeah, you're right, Cohen. I think one thing that's come out of COVID is that people have learned to rely on their own support systems to try and get them through difficult times. Just to circle back to you, Mia, do you think, just in terms of pricing, is there sort of a fair standard or that can be used to determine pricing so that small businesses in a situation like this don't overreach and charge too much? Is there anything that you can perhaps shed some light on there for us?
Yes, Jenny. So unfortunately, there is no percentage bracket that would automatically put a company in the safe zone, especially following the Babalegi and the Dischem decisions. It will depend on a company's market share, whether they can now be regarded to have market power, which would assign the temporary dominance as the Competition Tribunal recently awarded. And it would also depend on whether they are dealing with essential goods or services. So naturally, if you are a small firm who cannot be regarded as dominant in the technical sense of the word, and if you are not dealing with essential goods or services, you have a lot of freedom to price as you wish. However, I would still suggest that any price movements must be justifiable with reference to past pricing practices, as well as any changes in your input costs for it to be considered a reasonable price increase.
Thanks, Mia. I suppose it's fair to say that the minute the price of something shoots through the roof, there's immediately some awareness around whether or not the pricing is fair or not.
Yes.
Alyssa, back to you. So if the Booking.com decision came out of the US Supreme Court of Appeal, and you're right, we all love the notorious RBG, what do you think the situation would be in South Africa? Do you think the court would have come to a different decision? If you'd like to just let us know what your thoughts are on that.
Thanks, Jenny. I think that our Trademarks Act supports the decision that came out of the US court. So under Section 10 of the Trademarks Act, it lists the whole category of marks that are not capable of registration. And the first one says that it is a mark that doesn't qualify as a trademark. So a generic term for me would be something that wouldn't qualify as a trademark. You could never register wine for wine. That would be generic. And in such cases, no amount of use, no matter how well known the mark would be, it wouldn't ever be capable of registration. But the Act also says that descriptive marks are also not capable of registration, provided, however, you can show that through years of use or use that it has acquired a secondary meaning, it's acquired distinctiveness through use. So it's a very similar position as that of the US, and I think that a similar finding would apply here.
I think it's nice to know that, because I think a lot of people think that America has some special set of rules that only apply there. And because we know the trademark law is generally harmonized around the world, it's good to know that here we'd probably reach this similar decision. There's a question about what was the wine like. Alyssa, would you like to tell us whether the wine was worth the wait after your presentation?
Fairview never disappoints, but don't let me tell you, come to Cape Town, we need you.
Yeah, I don't think we need much encouragement on that front. And Cohen, so cool haircut. Are you willing to share the details of your hairdresser with the guests?
Absolutely. You can give me a call anytime, reach out to us. I don't think I'll bill you for it, and I don't think if it'll suit everyone, but definitely you can reach out to me and I can give you his details if you'd like. Jenny, your hours are almost the same, I can see.
Yeah. Yeah, very sharp. I think we've gone through the questions that have come through. Thank you very much. I know it's been difficult to try and put together a panel discussion that ties in a whole lot of similar concepts, but I think our three, Alyssa, Mia, and Cohen, I think you did a great job. Thank you for sharing your time and expertise with us. Our next presentation is going to be from Karima Sheikh, and Karima is going to help guide you through that difficult decision when you're in industry and you want to do something creative, create a label or create a jingle or an advertising campaign to promote your products or your services, and you engage with an agency. Who lands up getting the rights? So Karima, if you could take us through that, please. Thank you very much.
Good morning to everyone watching. This will just be a quick one on some housekeeping relating to your copyright. Now, most brand owners have an in-house marketing team to take care of their day-to-day advertising and promotional activities. The good news is that any content created by an employee in the course and scope of their employment will belong to the company. But oftentimes, brand owners also seek the assistance of an outside creative agency to assist with specific campaigns or other marketing content. In that situation, it is important for brand owners to, on the one hand, be able to exploit the copyright in that content, and two, to be in a position to enforce its rights against third parties. Now, depending on the nature of the content created, this will not always be a given, and it is sometimes necessary for the brand owner to take further steps to ensure that its rights are preserved. We should all be aware by now that copyright need not be registered in South Africa and automatically subsists provided certain requirements in terms of the Copyright Act are met. The Act makes provision for several types of copyright works, and the position regarding the ownership of copyright will be different depending on the nature of the work. Now, the general position in terms of the Act is that the author of the work, that is the person or entity that creates the work, will be the first owner. But some exceptions do exist. I touched on it earlier, where content is created by an author in the course and scope of his or her employment, the employer will own the copyright in the work. Another exception relates to certain works which are commissioned and paid for. I've created a cheat sheet which should appear on your screen now and which you can use as an easy reference tool when you commission and pay an outside design agency to create content for your business. The table covers typical content that one would commission as a brand owner, but is of course not exhaustive. You will note from the cheat sheet that in the case of literary, artistic, and musical works, and in the case of software such as mobile apps, the author, being the outside design agency, will automatically own the copyright in the content. It will therefore be necessary for you as a brand owner to take assignment of the copyright in order to enforce your rights. When it comes to cinematographic films, such as video content for social media platforms or TV adverts, the situation is a bit more complicated. Now, in terms of the Act, a brand owner who commissions and pays for or agrees to pay for a film automatically owns the copyright in the film. So that's the good news. It won't be necessary to take assignment thereof from the outside agency. The definition of a film in the Copyright Act includes all lyrics and musical works in the soundtrack that is associated with the film. So you will also own copyright in the accompanying soundtrack. But arguably, if you intend to use the lyrics or music separately from the film, you would need to take assignment thereof or seek permission to use those works. Remember, literary and musical works do not automatically vest in the brand owner commissioning the work. So what happens if you as a brand owner engage a design agency but haven't discussed the issue of copyright up front? The works are now created, but the design agency is refusing to allow you to use the content without paying a royalty or a license fee. Fortunately, all is not lost. The Copyright Act makes it possible for parties to enter into a verbal agreement regarding the license of copyright in a work. The Act also caters for licenses which are inferred from conduct. Therefore, one could argue in this kind of scenario that the perpetual royalty fee license to use the content was implied when entering into an agreement with the design agency. So there's little to no case law on the issue in South Africa, but there have been several decisions in the UK on copyright disputes involving marketing agencies and brand owners. In all of those cases, the courts have found in favor of the brand owner and have ordered that the copyright in the works be assigned to the brand owner. In some cases, the court found that there was an implied agreement for copyright to be assigned to the brand owner on completion of the brief, while in other cases, the court enforced an oral tacit agreement to assign the copyright. Our copyright law in South Africa is largely based on the laws in the UK, even though our contract law is a bit different. But I think we can assume that our local courts will certainly look at the UK cases to be of persuasive value when applying the provisions in the Copyright Act. But the best approach when engaging an outside agency to create content for your business would be to always ensure that the agency signs a deed of assignment covering any copyright works to be created. This way, you won't have to consult your cheat sheet to see what the default position is. You can have a template deed prepared with the details of the agency and the content to be created inserted each time you engage in an agency. Another important aspect of good housekeeping is good record keeping. For the most part, it is not possible to register copyright in South Africa. So if you intend to enforce your copyright against third parties, you will have to prove your ownership with reference to facts surrounding the creation of the content. It is a very good idea to keep accurate records of the facts, such as the details of the author, the design agency, the creation process, and the duration of creation. Litigation often arises several years after the content has been created, and fact-finding at that stage often proves difficult. The designers could have retired or immigrated, the agencies could have closed or have terrible records themselves. Litigation is costly, time-consuming, and energy-sapping for business owners. So it would be better to get your housekeeping in order in advance to avoid any gray areas or misunderstandings down the line. Taking care of these two aspects of housekeeping upfront will guarantee fewer headaches in the future and certainly less face time with your IP attorney. Thank you.
Well, thanks, Karima. You know, we actually enjoy FaceTime with our clients. So, and in these unusual times, this is about as good as the FaceTime is that we're going to get. I just wanted to ask you, there've been one or two questions that have come through on the chat line. And the question is, so what happens if the person who asked for the work to be created doesn't actually own the copyright in that work? How do they land up enforcing their rights? Is there some hope for them at the end of the day?
Thanks, Jenny. So the basic answer is they will not be able to enforce the copyright in the content. So and you wouldn't have access to the remedies in terms of the Copyright Act, which are unique. But all may not be lost. If you have used the content, and depending on the nature of the content, you could be able to establish common law rights, such as a reputation in whatever the content is. And in that situation, you could then be able to rely on the common law remedy of passing off or other forms of unlawful competition. Of course, if the content is eligible for registration as a trademark, then that is certainly recommendable that you register it as a trademark, and then you'll be able to access the remedies in terms of the Trademarks Act.
Thanks, Karima. I suppose following on that, a question that's come through also is, if you commission one design agency to create a work for you, and subsequently a second design agency does moderations or alterations to that work, how does that affect the underlying ownership of the copyright?
So our South African Copyright Act does make provision for copyright protection in what is called derivative works. So in such a situation, I would suggest that the brand owner takes assignment of the original copyright work in addition to the derivative work, because insofar as the derivative work is original, and in this context, original means, it doesn't mean state of the art or novel or unique. It simply means that it's the author's own work. It's his independent effort skill that goes into creating or updating the logo or whatever it were. You would then also have to take assignment of the copyright in the derivative logo, because copyright will vest in that logo separately from the original logo. So just to be safe, take copyright of everything.
Thank you, Karima. Somebody has asked, who is there's a beautiful painting that's the backdrop of your presentation, and someone has asked if you'd like to share the details of who the artist is, possibly.
Thanks, Jenny. I'm so glad people have recognized it and appreciate it. The artist is Nodstar. She's a Cape Town-based street artist, and she's quite popular internationally and in South Africa. And the reason I chose to showcase her today is because she focused specifically on inter alia women of color specifically, and it's a cause that's also very near and dear to me and you as well, as I know, and I thought that it would be lovely to showcase an artist with that message.
Yeah, it certainly is everything that I love about art: bright and vibrant and very creative. Thank you. Thanks, Karima. I think that's all from Karima for today. I'm going to hand over to Sophia, who's going to explain to us a situation that is rather unique in the South African patent context, where you have partially valid patent rights. How do you go about enforcing those rights? Sophia, if you'd like to take us through that. Thank you.
In my discussion this morning, I would like you to take away 3 key points. The first is that partially invalid patents are not enforceable in South Africa. Secondly, when a patentee becomes aware of prior art, it is important to amend the claims as soon as possible. Thirdly, while a patent application is pending, it's important to divide out any weaker claims. We often find that clients are unaware or perhaps only become aware a bit late of the fact that you cannot enforce partially invalid patents in South Africa. This even applies in circumstances where the patentee seeks to enforce a valid claim. So a patent is only enforceable once the invalidity has been cured by way of amendment. This, coupled together with the fact that South African patents are not substantively examined, places an onus on the patentee to make amendments to ensure that all the claims are valid. Amendments made while a patent application is pending are relatively straightforward. These are filed at the South African Patent Office, and since there is no substantive examination, they are routinely allowed. Once a patent application is filed, and one that has met all of its documentary requirements, these applications are typically accepted within 6 months from the filing date. Now, this is much quicker than the time that it typically takes for corresponding foreign patent applications in, for example, the United States or the European Patent Office to be examined. So it's best practice to request a delay of acceptance until the foreign counterparts have been examined, which may then form the basis of voluntary amendments in South Africa. This is also preferable to letting the South African patent application proceed to grant with the claims as filed, as there are more stringent requirements for post-grant amendments. In particular, the scope of the claims may not be broadened. Alternatively, or in addition to making pre-grant amendments, an applicant may file one or more divisional applications in which they divide the weaker and more vulnerable claims out so that the stronger claims may be more easily enforced. Divisional applications may only be filed before acceptance of the parent application. Nevertheless, it is sometimes necessary for patentees to make post-grant amendments. These are also filed at the Patent Office. However, they are advertised for a 2-month opposition period. In the absence of any opposition, the registrar will routinely allow the amendment. However, if the amendment is opposed, the proceedings will be transferred from the Patent Office to the Court of the Commissioner of Patents, and the amendment will be decided in the form of full-blown High Court proceedings. These seldomly take less than a year and a half for a court of first instance decision to be handed down. The grounds on which post-grant amendments may be opposed, there are multiple, but the most relevant for the purpose of this discussion is where the patentee has culpably delayed in applying for an amendment from the time they became aware of prior art. This emphasized the importance of not only making voluntary amendments, but making them as soon as possible after the patentee becomes aware of relevant prior art. In addition to answering a claim of culpable delay, an important reason for making voluntary amendments as soon as possible is to avoid a situation where a patent is close to expiry, and the only way to enforce the patent to get an injunction before expiry is to make an urgent application for a preliminary injunction. Typically, the amendment proceedings would have to be dealt with first, and these would usually not be completed before the expiry of a patent. For patentees, usually the value of enforcement of a patent is not the claim for damages after expiry of a patent, but it's the injunction before expiry. It is in certain circumstances possible to try persuade a court to hear an amendment application simultaneously with a request for a preliminary injunction, which have been successful in certain instances in the past. However, these are very risky proceedings and can be easily obviated by timeous voluntary amendments during the lifetime of the patent.
Sophia, I think that we sometimes feel overwhelmed by patent rights, and I think we sort of feel it's sort of very technical. I know it's definitely above my pay grade, but what I would like to ask you is, what is the legal basis for partially invalid patents being unenforceable? I mean, could you perhaps shed some light for us on that?
All right, thanks, Jenny. So actually our Act doesn't have an explicit provision prohibiting the enforceability of partially invalid patents. But there was a case decided by our Supreme Court of Appeal quite a long time ago, maybe about 20 years ago. It's called J.P. McKelvey versus Deaton Engineering. And they basically interpreted a few other sections of the Patent Act which implicitly direct the fact that partially invalid patents are not enforceable. So there is a provision where the Commissioner of Patents, so the judge that presides over patent matters, during revocation proceedings, if he finds that a patent is partially invalid, he must suspend the order of an interdict pending an amendment of the patent. So that basically implies that you may not enforce a patent until it has been amended to cure the invalidity of the patent.
I'm just wondering if there's any, I mean, we don't substantively examine patents in South Africa.
No.
So would that change the situation at all, do you think? I don't know if that's a fair question to ask. So
well, a substantive examination is in the pipeline. They are currently training up examiners. We don't know exactly when substantive examination will come into place, but certainly substantive examination will force at least applicants during the patenting procedures to amend their application so that their claims are enforceable. The only difficulty with this is it will depend on how long the examination will take in South Africa compared to examination in the major jurisdictions such as the United States or Europe. So if the South African examination process will still be much shorter than the European or the US examination, as is currently the position, then the benefit will only be while the application is pending. And, you know, if there's some examination or adverse findings that come up in Europe and the US after the South African patent has been granted, the patentee in South Africa will still have to make post-grant amendments. So it won't sort of be, you know, a fully ideal situation, but it'll be much better than the current situation, which just allows patentees to let their claims proceed to grant without any amendments in, more often than not, an invalid form.
So I suppose with that in mind, the best time to do the amendment would then be before grant. And is there an ideal time in the process before grant when making those amendments would be advisable?
So yes, that's correct. The best time would be to make amendments would be to make them while the patent application is pending. So amendments can be made any time after the filing of the application. We don't have provision like some other jurisdictions where you can file, you know, your preferred set of claims when you file your application if it's a PCT application. So it'll be any time after filing until before grant. However, our practice is rather to only file amendments up until acceptance, which usually happens about 3 months before grant. And the reason for this is because it usually takes quite a bit of time, in some cases up to 6 months, for the registrar to allow an amendment. So you don't want to have a situation where you file an amendment before grant, but the registrar only considers it after grant. Then there might be an argument that it was actually in fact a post-grant amendment and would therefore be subject to more stringent requirements. So the best practice is to do it before acceptance any time after the patent application has been filed.
So it seems to me that, in fact, out of both Karima and Sophia's presentations, that timing is everything. You have to really get your timing right to make sure that your rights are properly in place so that you can enforce those rights. Thank you very much, Sophia, for debunking the myths around patent claims. That's all from the middle section of our Crammer this morning, and the last section that we're going to have before we switch over to the unusual stories is a contribution from Advocate Stephen Budlander. I mentioned him earlier. He's a senior counsel at the bar in Sandton and a very well respected advocate and one with whom our firm has a long-standing relationship. Stephen's going to chat to us about what it's like to try and be an advocate in a virtual court. I think those of us who've ever been in court understand how advocates, they like the day, they like being able to present, they like being able to have an audience with a judge. So we asked Stephen to let us know what it's like to try and do it from the comfort of your own study. So if we could please just play Stephen's video. Thank you very much.
Good morning. I'd like you to cast your mind back just over 6 months to mid-March 2020. What would your reaction have been if I had asked you whether it was realistic and viable for a significant proportion of court work in this country to take place via remote hearings on Zoom or MS Teams? I certainly would have told you that neither the courts, nor the advocates, nor the attorneys were ready for such a move. And I would have pointed you to the difficulty of even getting courts to agree that evidence from overseas witnesses could happen via video conference during trials. But like so much else, the legal world has seen a massive shift as a result of the COVID-19 pandemic. We are now in a situation where literally thousands of matters have been dealt with successfully by our high courts via virtual hearings. We have seen close on 100 appeals being dealt with by the SCA via virtual hearings. And while the Constitutional Court was slower to move to virtual hearings than other courts, this term all of its hearings have also happened via virtual means. And I think to the surprise and delight of most of us, on the whole, it has worked really well. There have been obvious difficulties and obvious exceptions, but on the whole, it has been a great success. The question is, what are the implications going forward? As we hopefully move towards the end of the COVID pandemic, what does this mean for the future? And it seems to me there are 5 key takeaways. The first is that it's now been shown that in the right kinds of cases, virtual hearings can be used very effectively and can produce a significant saving of time and costs and efficiency. An example is urgent court. To my mind, urgent court will never be the same again. I can't imagine that any sensible judge would now agree to drive down into the CBD in the middle of the night to have an urgent court hearing when he or she could simply send out a Zoom link and proceed on a Zoom hearing. Similarly, applications and appeals have taken place very successfully with people sitting in different places all over the country and sometimes all over the world. And again, it does seem to me that that might be something that can be effectively used in the future. Even in respect of trials, while there's an obvious disadvantage in having to have cross-examination and oral evidence via virtual means, examples have shown that even that can take place quite effectively in trials. And early on in the COVID-19 pandemic, there was a helpful ruling by the Australian Federal Court, which held in the matter of Capic versus Ford Motors, that it should not be business as usual, and that measures should be taken to have even extensive trials held via virtual means. And that to some extent merely reflects what has already been happening in the arbitration space for a number of years. So while I don't think that we're going to move to an exclusively virtual hearing system, I do think that in appropriate circumstances, virtual hearings are now going to be used, even post-COVID-19. The second is the question of the case line system. Now, for those who don't know, the case line system is a system that was implemented by the Johannesburg High Court and Pretoria High Court. And it is a document and pleadings management system whereby all of the pleadings and documents can be accessed electronically via the web for those involved in the case. Now, case lines, of course, existed before virtual hearings, and it doesn't depend on virtual hearings. But the COVID-19 pandemic and the move to virtual hearings has, to my mind, proved the virtue and value of case lines, and most importantly, forced people to move on to it, because it enabled everyone to sit in different places and still have access to the same documents. I was reluctant about case lines initially, but having moved to case lines now, it seems to me to involve massive advantages for all of those involved, judges and practitioners alike. Because the ability to have a single set of uniform electronic documents with a single set of pagination, and the ability for an advocate presenting a case to say, I'd now like to take you to this page, click on the page, and everyone involved is immediately taken to that page. It produces enormous efficiency, and when it is used properly, enormous advantages. And my experience, having argued matters on case lines, is when I then moved to other courts, including appeals, it felt like there was something obvious missing. And it'll be very interesting to see whether we now move to a situation where other high courts, the SCA and the Con Court also move to a case line system. And I think there's a huge amount to commend it, and that's what we've experienced in the past few months has proved it. The third takeaway is that for all of this to occur properly, the resourcing of the judiciary is key. It is clear that some divisions simply didn't have the necessary IT infrastructure to make virtual hearings work consistently and well in a way that took place in other divisions. And that is a real problem, because the effectiveness of the virtual hearings depends entirely on the availability of that IT infrastructure. And similarly, with regard to case lines is only as strong as the network that is available to the high courts. And so when that network goes down, that causes terrible difficulties. So the resourcing of the judiciary going forward from an IT perspective is key. And if needs be, it seems to me an area that corporates need to get involved in assisting in, because we all depend on the proper functioning and the effective and efficient functioning of the courts. And this is a key area that needs to receive focus. The fourth takeaway is a question I've been asked repeatedly. Was your advocacy different via virtual means? And it seems to me that advocacy via virtual hearings is different from physical hearings, because advocacy via virtual hearings has to be very much focused on content rather than style. And what I mean by that is, in a virtual hearing, the format rewards those who quite carefully and systematically take the judicial officer through the relevant facts and law, rather than those who might seem to overwhelm the judicial officer by means of a passionate address delivered sometimes at high pace, but without that careful reference to facts and the law in the way that the judicial officer is taken with you. And so I do think that advocacy via virtual hearings is different. And I do think that many of us have adjusted our style of advocacy in order to be effective via virtual hearings. And I think the idea of favoring content over style in hearings is a good thing for the judicial system, and one we should welcome. The last point is that virtual hearings cannot become an excuse for flouting open justice principles, and open justice remains a concern. But there is no reason that virtual hearings shouldn't in fact promote open justice rather than retard it. And you saw that in the Constitutional Court hearings that have happened this term. Those hearings were all streamed live on YouTube. And so rather than have only a handful of people who were in court witness the hearing, or make viewers depend on whatever the news networks happen to be carrying on their broadcasts, it enabled a real-time open justice system. And I think that was a fantastic development, and one that needs to happen in courts across the country. Because a system whereby the only people with access to the Teams link or the Zoom link are those who are the litigants is a problem. But there's absolutely no reason that proper measures could not be put in place to allow streamed hearings, as the Constitutional Court did. And it's definitely something that should be looked at. The question, of course, remains, when we eventually and hopefully overcome the COVID-19 pandemic, do we simply slip back into our existing practices and mechanisms, or do we take advantage of what the virtual hearing system has taught us? I hope that it's the latter, because as valuable as in-person hearings are, and whilst those plainly contain a number of advantages, we can take the best of what we've learned during the COVID-19 pandemic and try and make use of that, so that going forward, the new normal is in fact a situation which is better and more effective than the situation which preceded it. Thank you very much.
Thank you. We'd like to express our thanks to Advocate Stephen Budlinder for giving us his time to do the video. Interestingly enough, and I think I can say this without him being offended by it, he said that it was harder than he thought it would be to do. And I think that that's possibly the lesson that all of us have taken from these unusual times, is that things have been harder for us to do than we thought that they were to do. But I think that a lot of people have taught us a lot of smarter ways of doing things, and interesting ways of engaging with people, despite the fact that we can't be face-to-face with people. So in our final section of today, I'd like to introduce you to two very special individuals with two very vibrant and exciting businesses. The first of our unusual stories today is presented by Rainer van Wyk, who is the financial director of a local company called Lekker Slaap. I think it'll be interesting for you to hear what he has to say, because I think the tourism industry was one of the industries that was particularly hard hit by the COVID pandemic. And coming hot off the heels of the Booking.com decision, we thought that it would be nice for Rainer to speak to us about how Lekker Slaap managed to cope with the COVID-19 pandemic and how they had to reinvent themselves in order to continue to have an effective business. So let's watch his video, and maybe that will inspire us. Thank you.
Hi, I am Rainer van Wyk, and I'm the financial manager of Lekker Slaap. Lekker Slaap is South Africa's largest online accommodation booking site. We represent over 25,000 properties, and we facilitate hundreds of thousands of bookings every single year. Now, 2020 has been the most challenging year for us as a business. South Africa's lockdown restrictions banned domestic travel, which meant that we could not facilitate any bookings. And while we were generating zero revenue, we had to sustain a business with significant monthly expenses and a staff count of over 100 employees. And while keeping control of cash, we were well aware that our primary focus should be the long-term sustainability of our business. And lockdown turned our industry upside down. But keeping our long-term goals in mind, we continue to service the needs of our guests. As a result, we guarantee 100% refund on all affected bookings. We work very closely with our properties that we represent to ensure that this was done as swiftly as possible. We also cash flowed millions of rands in refunds on behalf of these properties to ensure that our guests return to us as soon as our business resumes. Of course, in the short term, various measures had to be taken to ensure our survival. We performed regular cash flow analysis, we made use of the government-backed COVID funding, and we cut costs across the board. Unfortunately, that included some layoffs. Although these short-term measures were really important, we have already seen that focusing on the long-term goals was the right choice. Since the move to level 2, our business has significantly rebounded. In fact, we are now doing more business than what we were at the same point last year. As a result, we've been able to rehire our staff at a furious rate to ensure that we keep up with demand. Now, although the effect of lockdown will still be felt in the coming months, it is clear that to focus on the well-being of our guests has set us up for continued growth well into the future.
Well, that's me caught unawares there for a minute. Sorry about that. I did want to just tell you that there have been one or two questions that our audience would have liked to pose to Advocate Budlinder. So I'm going to try and see if I can perhaps ask one of them, and I'm going to ask any of the panelists that are still here if they'd like to chip in. One of the questions was to Stephen Budlinder was, would hard copies of documents still be available since there is some anxiety about loading documents onto an online system because those documents could potentially be deleted? I can tell you that the Caseline system is a secure network, so only people who are invited to the papers will have access to those papers. So you have to create a profile and a password, and only when you do that can you actually have access to the documents. As attorneys, despite COVID and despite the world going paperless, I can tell you that a lot of us are still very much married to paper files and paper copies. So we as attorneys would keep our own paper versions of documents, particularly if the evidence is voluminous. I hope that answers your question, but if you have any further questions relating to that, we would be happy to answer them. I'm also just looking at my phone. There is another question which says, what happens when there is a network failure where the system cannot be accessed during virtual hearings? I think that is problematic. and I'm not entirely sure how we would deal with that, but I suspect that in an event where there is a network issue, the matter might have to be relocated to some type of network where people will have access to it. Can I say that I'm going to try and see if I can find out what the answer will be to that question, and then come back to you. I don't know. Cohen, do you look like you might want to answer that question?
Thanks, Jenny. On that, I think it's just perhaps just on the first question, I'd just like to add to you, of course, there is authenticity if the authenticity of a document might also be a concern. I think that's where actual physical hard copies are also come into play, and that's why we generally like to keep physical files as well. Regarding the second issue, it is definitely have to manage it with the court, and I think with the judge in question. I've had instances where there was connectivity issues, but you'll perhaps just have to manage it with the judge as to perhaps just a brief, not postponement, but you'll just take a brief break to kind of try and sort out those issues. But I mean, it is technology and these things do happen. We aren't in a perfect space yet, but hopefully as time progresses, we can work those issues out as well. But it is a real concern and it does happen, but generally you try to manage it with the judge and with the clerks and with your opposing counsel, as it were.
I can also just chip in and say that Mia's given us some guidance on this too, to say that Caselines is cloud-based, so it is possible to retrieve documents that have been deleted. I hope that, I think it was Grace was the person who asked the question. I hope, Grace, that we've answered your question sufficiently, but I think I don't want to jinx today by saying so far so good we've had with our networks here. So I think we just have to try and remain positive and, as Cohen says, find ways around that. The second unusual story that we'd like you to watch today comes from a lady by the name of Danielle van Wyk, who has a business called Pega Foods. She literally recreated and reinvented her business during COVID, and I think you'll find her presentation very inspirational. Thank you.
Hi, my name is Danielle Dutoy, owner of a small business called Pega. Pega is a Zulu word to cook, and that's what my business is all about, teaching people to cook. My main market is children and domestic workers. For 13 years, I've thoroughly enjoyed upskilling students and seeing their confidence grow. Lockdown closed my business overnight. For someone who hates change, I had to adapt quickly. Without any clarity in terms of revenue, I knew I had to keep my brand alive. I chose to post a recipe a day on social media. The result was fantastic. Families were back in the kitchen and looking for fresh, simple cooking ideas. Many followers asked for the post to become a recipe book, a long-standing dream of mine, so the idea was born. But with zero experience in this field, I reached out to a good friend of mine in Cape Town, and together we made this dream a reality. I rallied my 2 sons, my husband, and we cooked, styled, and photographed. Within 3 months, we had Pega Lockdown Recipe Book published and the first issue sold. An online store was quickly developed. Thank goodness, a new revenue stream was born. With year-end looming, no Christmas parties in sight, Pega now offers companies your own branded Pega Lockdown Recipe Book, in memory of this extraordinary time we have all experienced. Like so many businesses, big and small, agility has been our greatest learning. We have learned to adapt and support our community.
Well, I don't know about any of you, but all that food has made me feel rather peckish. I would like to encourage you all, please, to look on our website at the unusual stories. We've posted a variety of unusual stories, which we will be playing every day. But do go and have a look at them. I think you'll find them very interesting and inspirational. So that's us for the Monday. Thank you very much for joining us and for giving us your time. Hopefully next time we see you, we'll be able to see you face to face, and maybe we can share some of Danielle's cookies over a nice cup of coffee. I hope that you found today to be inspiring and educational, and that you will find this will continue throughout the rest of the week. Thank you very much for your time, everyone, and thank you to our speakers and to our technical team who made this all possible under these challenging and unusual times. Thanks a lot, everyone. Have a great day. Bye-bye.